Hi, I'm Jeff Rivard, and I'm one of the attorneys at Sapega, Daly, Pope & Perry, and I'd like to talk to you about the unlimited marital deduction. A U.S. citizen can leave an unlimited amount of assets to their surviving spouse when they die, entirely free of estate taxes. There's no estate tax applied at the first death, but when that surviving spouse themselves later dies as a single individual, they will have no surviving spouse, and there is no unlimited deduction. And it may very well be the case that the amount they originally inherited estate tax-free when their first spouse died may be enough to put them over their personal exemption amount, especially when added to their own accumulated assets. So what can be done? Well, if the second spouse happens to have remarried, then they too will have the opportunity to leave their assets to their surviving spouse entirely estate tax-free. But from a planning point of view, what we commonly recommend is people consider setting up a credit shelter trust. The idea is a credit shelter trust is funded with an amount of assets up to but not exceeding the personal exemption amount of the first spouse who died. The surviving spouse is a beneficiary of that trust, but they don't actually own the assets in that trust. And more to the point, the assets in the credit shelter trust are not part of the taxable estate of the surviving spouse when they die. That way, between the couple, they can make full use of the personal exemption amount of the first spouse who died. If you have any questions, give us a call. Thank you.